Item number 48. Taken on Friday, madam. For the present given today. 48.
Or Friday.
Problem. 7.
It is not received, I think.
Is not Bala, it is suscited case, suscited.
Can copy not received.
Classified.
Please, your lordship. 67 days in custody, your lordship. POCSO is there.
No. CD. Notice to respondent number.
Blessed.
Wait, please, your lordship. Your lordship, this case has been just stated, your lordship. Your lordship, sections under POCSO, your lordship. Behind the bar.
Can copy. Notice.
Can we pass over item for time being? Yes, legs.
For the time being.
Timing.
In this case, petition is behind bar since 8 December 25. Case under section 21C, my lord, NDPS.
CD.
My lord, case is charge sheeted, so.
Can copy. Okay.
It's too long, my lord. It's from Gauhati, my lord, metro.
1780.
Obliged.
May I please, your lordship? Regular bail application, POCSO Act is involved. Lordship. The notice will go. Next day he may be called. Lordship.
CD and notice to.
Can it be on 17th Lordship, of August? 17th. Deeply okay.
Wildlife is there, my lord. CD may be called for, my lord. This has been registered by police station, my lord. So CD, my lord, will be procured by the public prosecutor. So offense is under wildlife protection, but BNS is also involved.
CD is with police.
CD is with police, my lord. It's a police case, my lord.
Pokrajhar,
You should record your presence
Yes, my lord. As special PP wildlife.
at council. PN Goswami. Senior. Also add additional people. The CD. Second on.
Obliged.
Obliged.
May I please, your lordship? Petitioner 39 days to this custody, my lord. 39 days today, my lord. 21B, 5.4 gram heroin has been recovered from the house of the petitioner.
39.
39 days today.
CD.
14. Can it be 14? My lord? 14.
May please, your lordship. Okay, my lord, FIR, your lordship will find at page 13, my lord. Page 13, my lord. My lord, buffalo was, my lord, recovered while transporting from, my lord, Dhamaji to, my lord, Nagaon, my lord. Page 13 is the FIR, my lord. May I read the FIR, my lord.
Who are you, driver?
Yes, my lord. Petitioner one is the driver, my lord, of vehicle number 1147, and petitioner number two is the, my lord, handyman of the said vehicle, my lord. From our vehicle, my lord, 5 numbers of, my lord, buffalo was recovered, my lord, and basic allegation is, my lord, we have transported the buffaloes without any, my lord, permission, my lord.
It's been essay under section 303, man. It has been essay under section 303.
And in page 18, my lord, kindly see, my lord, this is the, my lord, sale receipt, my lord.
We can't verify that.
And so far,
See the CD.
so far, my lord, allegation of, my lord, permission is.
How many days are you there?
17.
How many days?
Already, my lord, 27 days in custody, my lord. And so far, this case is concerned, my lord, permission is not required, my lord, while, my lord, transporting from within the state, my lord.
17.
May I take your lordship to the
But do we know whether it is transported within the state or outside?
lordship? It was, my lord, recovered in, my lord, Dhamaji district, my
It will
lord.
definitely be recovered somewhere,
Lordship, my lord.
but its destination is not known.
And there is no allegation is there also, my lord, to the effect that, my lord, we have transported to outside the state, my lord. And so far, my lord, section says, my lord, within the state, my lord, no permission is required, my lord.
No permission is required even for theft.
And in the FIR also, allegation of theft is not there, my lord.
That 303 is there.
Section is charged, my lord. If your lordship go by the, my lord, FIRHL, my lord, there is no allegation of, my lord, theft, my lord. My lord, may I pray for a
Papers always come later. At the time of carrying, you have no papers.
So 12 wait.
ruling?
Mate, please to your lordship, Mr. P. Bodlo is on legs, kindly pass over for time being.
Who? Which item?
10.
Here, it's a conscious position under 20B, my lord. The 6 days offense today is 54 days.
Right, let him come.
Yes, ma'am.
Please, your lordship, this is a tag matter, lordship, arising out of the same FIR. Another bail application is also pending regarding the same FIR. Bail application number 2126 of 2026, Wahidul Jamal, Border State of Assam. Lordship, the next date is on 17th August. These two matters may be taken up together.
At least the matter along with BA number
2126 of 2026,
on 17.
17th August.
Ekan SMS can copy.
Yes.
Deeply obliged, lordship.
Please, your lordship. He's the driver of the auto, my lord, where from the passengers, my lord, commercial quantity heroin was recovered.
Now sit.
Matt.
Ship is fixing a date.
May I please, my lordship? The regular bail execution petitioner in language in the last 22 days, my lordship. And the allegation is basically there's some miscreant enter into the Senko Alankar jewelry shop, my lordship. Thereafter, they looted, my lordship. And in the FIR, my name is not mentioned, my lordship. There is no specific role attributed to me. My name, my lordship, comes into play when the co-accused got arrested. They have taken my name, my lordship. And nothing mentioned in the FIR against me, my lordship. And I am languishing in just last 22 days, my lordship.
Only.
My lordship, pages 21, they FIR, my lordship.
More than around 7 crores jewelries were.
Yes, CD.
Searched.
Deeply obliged, my lordship.
Allegations against me, 8 of POSCO, my lord.
And today is a 45 days. Section 8, my lord, if your lordship will kindly see page 12, the FIR, my lord. It shows that this FIR has been caused. My lord, that's absolutely misuse of POCSO, my lord. I'm behind the bar for about 45 days. If your lordship kindly see what has happened, and page 12, my lord, and handwritten is page 14, my lord. Father has lost his affair, claiming that and age of 17 years, and I have touched while my lord riding the motorcycle, scooter, my lord, that I have touched his private parts. That is an allegation, my lord. The language which has been used, my lord, you see.
Anyway, POCSO is there, we
Yes,
have to issue notice.
Because 19 will be the 60 days, my lord. These are 5 years maximum punishment.
Right, but we didn't ask you to come after 45 days.
14, may I, 14, 1, 4. 19 will be the.
My pleasure, Lordship. Today is 27 days, my lord. We end the war.
My lord, oh, sorry. My lord, can it be, my lord, may I be, can it be 13, my lord, 14?
All right, 13.
My lord, much obliged.
My lord, intermediate quantity, my lord. And suspected to be heroin, my lord.
All right, CD.
On 18, my lord.
Obliged.
Please, your lordship, charge sheeted matter, kindly call for TCR.
Scan copy of TCR.
25.
May I please, your lordship? This is application article 43, 483, application under 483. Lordship, allegation is this cyber crime. So, Lordship, petitioner is produced before the magistrate after 48 hours. No incriminated materials recovered from his possession, Lordship. During the police custody also, 2 days police remanded sent by the judicial magistrate. After 48 hours, they have produced before the judicial magistrate Kasla. The petitioner also have life-threatening diseases, cardiologist patient. During the judicial custody, the patient is under now under medical treatment. And see the lordship, page number FIR, page number 14. May I read, lordship?
Yes, PP, any
My lord, here, my lord, the arrest memo is enclosed, my lord, along with the, my lord, that is the forwarding report, my lord. Arrest memo is on, my lord, annexure 4, page 24, my lord.
So from where from are you saying he was produced after 48 hours?
Yes, lordship, as per FIR, they have arrested 9/7/2026. But the concerned police
Where is it
before the
dated?
produced before the judicial magistrate 11/7/2026. Also, sir, lordship, Caesar memo also mentioned that the Caesar date is also 9, lordship. And you see the page number.
What is your name?
Page number 20, Lordship.
What is the name of the petitioner?
Azhar, petitioner name is Azharul Islam. Lordship, the petitioner is detained from the restaurant, from his restaurant, but in arrest memo it is shown that he is arrested from the police station at 11/7/2020. Petitioner is arrested from detained from his restaurant, Disang restaurant, 9/7/2027. Petitioner also life-threatening disease, Lordship also. Nothing has been recovered from his possession. Just only mobile phone is recovered from his possession. See, personal is mobile phone, Lordship. After detain of the petitioners, inquiry is conducted before one another accused house named Shahjahan. His seizure and some article has seized by the concerned police. Page number 20. It is date shown that 9/7/2026. It's clearly mentioned. Also, FIR also clearly mentioned that they have detained from the Disang restaurant 9/7/2026 or produced before the judicial magistrate 11/7/2026. It is clear violation of 22 Article 22 and 187. On petitioner also life-threatening disease. Nothing has been recovered from his possession. Only his mobile is seized.
The FIR, it appears they were this petitioner was apprehended on 9th itself.
But in my lord, one of the my lord seizure list also my lord, that is my lord 9/7/26, and one of the seizure
And
list shows
that
my
teaser
lord,
list pertains to somebody else, but so we are not
my lord.
going by that. But
As per FIR, it is
as per
clear-
FIR, it is clearly stated they received the information at 3:30, 9/7/26, and they followed it up, and apprehended this particular fellow, Azharul Islam.
Yes, Lordship. Lordship, after detaining the petitioners, the inquiry is conducted on another accused. It is also mentioned after detain of the petitioners. As per the police statement, after they get from the information from the petitioner, they have conducted search to others petitioner, namely Shahjahan. And recover some articles from his house. It is also mentioned in the seizure list, also in FIR also. On that, this seizure list is mentioned that the seizure list
Allegation is also that they were planning to commit.
planning to commit, not
cyber crime.
committed.
My lord, that statement is planning to commit.
On the face of it, does not really disclose anything. All right, we have to let him go because of the admitted time. Apparently, he was produced on 11th.
My lord, it is produced on 11 because my lord, it is my lord forwarding report is there. And my lord, in the my lord arrest memo, they stated as 11/7/2026.
Arrest memo is also
Date
seen
and
that
time of
clearly.
arrest is 10 AM. my lord. Yes, sir.
Cannot be,
Yes,
cannot be. All right, we'll pass orders.
my lord.
May I please, your lordship? My lord, this is the petitioner's second bail application matter, 543 of BNSS, my lord. Sections are section 6 of the POCSO Act and 64(2)(f), 65(1) of BNS, my lord. Charge sheet has been filed and the petitioner is in custody for 217 days, my lord, as on today, my lord. The first bail rejection order may kindly be seen at page number 26, my lord. Bail was rejected on the ground that the nature of offense is serious, my lord. But as of today, my lord, the victim and her parents have been examined, my lord. No chance of tampering with the investigation, my lord.
Not even a month has gone by. Just 15 days ago.
My lord.
15, 16 days ago, it was rejected.
Yes.
Scan copy. Yes, sir.
My lord, notice to my lord respondent. My lord, notice part already mentioned.
Notice for this.
Please, your lordship, kindly pass over the matter. Typing, your lordship.
May I please, lordship? My lord, intermediate quantity of ganja was recovered from the possession of the wife, my lord, who is already arrested, my lord. And the petitioner has filed this AP, my lord. He is an e-rickshaw driver, my lord. 1 kg ganja, my lord, recovered. FIR is page 14, my lord. Wife is already, my lord, behind bars for around 23 days. my lord. Page 17 is the forwarding, my lord.
So recovery was made from your house.
That is there, my lord.
All right, CD.
Following.
May I please, my lordship? Transit anticipatory bail application, my lordship. The petitioner served a notice under section 35 clause by 3 for its appearance, my lordship, at JS Police Station, Uttar Pradesh, my lordship. And I was received the notice on 8th of July, my lordship. I was supposed to appear on 10th, my lordship. And lordship, I was not in a position to appear only 1 day in middle. So my lordship, now the thing is that my lordship, as because section 35 clause by 3 says that the notice have served upon me, I am not comply with the notice, they can arrest me, my lordship. So that is the first ground, my lordship. And the second thing is that my lordship, they have
Where is the rejection order?
your lordship, it was not rejected. I have withdrawn my lordship.
Yes, where's the FIR?
Notice my lordship, page number 12, my lordship.
See the FIR first.
Notice only served upon me, my lordship.
No FIR is there.
No far is there, my lordship. They have telephonically informed me, my lordship, that 30,000 amount of rupees has been credited to your account. We need to ascertain the facts. You come to the police station, my lordship. That is the things, my lordship. Lordship, I'll go there. In the meantime, my lordship, I may be protected, my lordship. As because 10 July is past, my lordship. Now they have the right to arrest me, my lordship. So my right to liberty, my lordship, cartel in the police station, my lordship. And they can arrest me, my lordship, without warrant, my lordship. My humble prayer before your lordship, I may be given some specific protection, my lordship, until I appear there, my lordship. Or no coercive action taken against me, my lordship. I'll appear there, my lordship. And I have annexed of this honorable court to coordinate when judgment what is honorable court also granted. Similarly, footing 35(3) notice, this honorable court granted bail, my lordship. And judgment I have attest, my lordship.
This transit bail.
Yes, my lordship.
So this is also for transit bail.
My lordship, transit bail, yes, my lordship. For limited protection, my lordship, I'm praying, my lordship.
Why can't you approach there?
Lordship, yes, because I was supposed to appear 12th of July, my lordship. And I was served notice 8th of July, my lordship. 1 day was left. So,
Which place?
my
Which
lordship.
state?
MEC, my lordship, Uttar Pradesh.
Uttar Pradesh.
Yes, my
So
lord.
go to Lucknow. Go to Lucknow. File
Yes.
anticipatory bail application there. Why are you here? You appear before the IO, they will arrest you. Don't appear. File anticipatory bail there.
The transit, my lordship, they also arrest me, my
They
lordship.
never came to search for you. How will they know when you go? We are not entertaining this kind of applications anymore. Dismissed, will pass order.
Chief Douglas, no.
May I please, your lordship, pointed to BNSS application lordship. The FIR, your lordship, will find at page number 9, lordships. Allegation is under section 8 of the POCSO Act, lordships. Page number 9 is the FIR, lordship. With due respect, I beg to inform you that on 15/6/2026 at about 12 noon, my daughter, namely so-and-so, aged about 15 years, was returning home to our residence at Koilawari Place from Onidho, accompanied by Simoti so-and-so Nayak. While they were on their way, one 19 Khan, a resident of Koilawari village, approached them and upon seeing invited them to his garden to eat mangoes and lychees. Thereafter, both the girls started searching for mangoes and lychees under the trees in the garden. After some time, 19 Khan invited them inside his house. Believing him, both the girls
Yes,
entered
TD.
the house.
All right.
And this person is
Also, my lord, notice to respondent.
obliged, lordship.
TD and notice.
Appearing for Advocate B. Ashad. Due to his sudden health issues, he is not able to come to the court today. May the matter be fixed next Friday or Monday, Your Lordship.
By next Monday, we can call for the CD itself today. If you want to adjourn till next Monday, anyway, your choice. All right, the prayer of is again on Monday.
Chapter Your Lordship.
PA's bail application, my lord. Go, my lord, section, my lord, POCSO is added, my lord, this is not a case. POCSO simply set out what to the petitioner, lordship. What is happened, my lord? Now, my lord, kindly come to the page number 16. This is the FIR, my lord. M. Pokha Tupla Boru, my lord. This is the villain, my lord. Second Pokha, Aminul, and Rofidul. I'm not the petitioner, my lord. They, my lord, went to the, my lord, along with the, my lord, victim to the Kaziranga Dhaba, the Howley lordship. Thereafter, they come to my dhaba. My name is my lord Deukar Dhaba. They committed my lord crime in the Kaziranga Dhaba. I am the owner of the Deukar Dhaba. Thereafter, they confess, my lord,
my lord, for a police, my lord, they went to my dhaba lodge. So I'm the owner of the dhaba lodge. So my lord, police is searching me. My name is not lodge in the FIR. So my lord, this is not a POCSO simply set lordship. So I have stated, my lord, in paragraph 7, my lord. Committed crime in my lord, Kaziranga dhaba. Thereafter, in the police custody, my lord, they have, my lord, stated, my lord, about my dhaba, Deoga dhaba. Yes, my lord, they came to my dhaba for my lord, lordship, along with the victim. I have stated in paragraph 7, lordship. Deoga dhaba is my in front of my dhaba. At least, my lord, no coercive action, my lord. I will appear, my lord. I will state everything. On the basis of my lord, statement of the accused, arrested accused person, police is behind me, my lord. Yes, they have come to my dhaba. My dhaba name is, my lord, Deoga dhaba. After they went to the Kaziranga.
You admit they came to your dhaba, whether it is Kaziranga or Deoga?
No, my lord. Deoga dhaba is different, my lord, in front of my dhaba. Kaziranga dhaba. Thereafter, they went to the Kaziranga dhaba. They have committed their crime. Maybe they committed crime, lord, along with the victim also. So, my lord, when they were in the police car, so they narrated everything, my lord, from the morning, how they came from the home, in where they were meet the accused person. In that, my lord, my name is coming, but my Deoga dhaba. Admittedly, my lord. Offense is, my lord, committed, my lord, in Kaziranga dhaba. It will reveal, my lord, video. In the, my lord, narration, even before the police custody, my name is, my lord. Yes, they have come, my lord, to my lord.
Third learned counsel for the petitioner, and additional PP. There is an application under so and so. The fact of the case is that page 15. On page. Call for the CD. We are having regard to the fact that the petitioner is not an FIR named accused. It is provided that in the event of his arrest, in bail of rupees 1,000 with 2 securities of like amount to the said. Provided that it shall appear within a period of 10 days from today. Shall not try to influence or intimidate witnesses.
Deeply obliged.
Notice to respondent.
Notice may be go to the box office. Highly obliged.
Here, your lordship, is FIR is at page 11. The petitioner is behind bar for 35 days. He is the manager of a restaurant, hotel, your lordship. It will be this one. Persons were caught, your lordship. They are not minors, your lordship. Adults, your lordship will kindly come to
Who are you?
I am the manager of the hotel, Your Lordship. Already behind bar for 35 days, Your Lordship. Page 17 is the grounds of arrest, Your Lordship. Owner of the hotel was granted the privilege of pre-arrest bail by this honorable court, Your Lordship. Now, page 17 is the grounds of arrest, Your Lordship. Second paragraph. The informant, namely Navajyoti Das, along with 11 other local public laws than 18 affairs, so and so. Then exactly, Your Lordship, clause 3. Upon verification of guest register maintained, it was found that room number 102 had not been allotted pre-booked by name of any male occupant, despite the male person being found present therein, thereby establishing deliberate concealment of falsification and non-maintenance of mandatory guest records of the so and so. That during the course of investigation, the investigating officer recovered incriminating unusual material so and so. Now, what Your Lordship adult people do within the four corners of wall, I don't know, Your Lordship. They have booked it, and a manager, Your Lordship. Trafficking will not come, Your Lordship, on the face of it, Your Lordship, as per the definition is there. But be that as it may, already 35 days behind bar, Your Lordship. Thoroughly interrogated, Your Lordship. Owner has also been granted the privilege of pre-arrest bail after perusal of the case there, Your Lordship. Therefore, Your Lordship, probably further custodial detention is not required, Your Lordship. Everything has been seized, Your Lordship. Statement has been recorded, Your Lordship. According to them, the statements of the boys and guards, Your Lordship.
Yes, people.
Only the part is that Immoral Traffic Prevention Act section is there, man.
35 days is.
35 days, that is also true, man.
This order dated 7, middle college. There are 1, 2, 3. Okay, go. Submitted that by order dated 07/07/26 in AB 1531/2026. The co-accused stroke owner of the bill has granted the privilege of interim pre-arrest bail. Full stop. Para.
Subsequently made absolute.
Which was subsequently made by order dated 24/7/26. In the 10th case, the petitioner is the manager of the said hotel who was arrested on
Your Lordship, 36/2026.
06 and has now spent 35 days in custody. Stop having regard to the above as well as the period of detention order and as well as to the nature of the allegations. Further detention of the petitioner may not be necessary. Bail 50,000 2 securities.
Deep problem.
Your Lordship. Lordship, intermediate quantity, Lordship. Lordship, I am a lady, Lordship. My minor children are with me, Lordship. My minor children are at home, Lordship. Kindly peruse the notice, Lordship. That has also been not complied with, Lordship. Was served to a minor daughter of me, Lordship. Sonia Devi, aged about 17 years, Lordship. Page 22, Lordship. Father and mother both are in custody, lordship. I am the mother, lord.
How many days?
Till today, 25 days, lordship.
Only.
Father and mother both are arrested, lordship. I am the
Hmm.
mother, lordship, and notice under section 48 also not complied with,
Why are you saying father and mother, father and mother?
lordship. Husband and wife, lordship.
Husband and wife. Hmm. See the CD. Give it a CD.
Lordship, can it be on 13 August, lordship? 13 August, lordship. 13 August, lordship. Oblige, lord.
Yes. But my lord, in this case, forest should appear, my lord.
Hmm?
Forest matter, my lord, pending of 25. Yes, my
You
lord.
shall notice
For forest should.
to Forest Council.
We have, sir, no, given a copy, my lord.
Special PP. But forest is not mentioned.
But we have served a copy, my lord. The notice should be there, my lord.
You inform him. Inform him.
Yeah, but let. Oblige, my lord.
Wait, please, lordship. Lordship, kindly call for CD as well. Notice may be also.
CD and notice.
Notice যাব না। Notice তো যাব না। এখনো দিদি, 13 মানত। 14।
I am the informant, my lord. It's a
Notice. CD also required.
PCI may be called for me.
Can PCR, my lord. Sir said submitted.
This year.
Question number 3, new. This one name.
28 hood.
Can it be after 1 week? In this case, person number 3 is newly appointed, lordship. Newly made a party as number 3. Notice may be issued, but petitioner had not issued the notice, lordship. In earlier order, Honorable Court was directed to issue notice, lordship. I'm for number 2, lordship.
Where is 3?
Not appear, lordship. He is the victim. I'm the informant.
Partition. Oh, minus for. Under 28. 28.
Huh?
28, my lord.
Yes, yes.
At that day, he was absent, my learned friend was absent, that
So I have given documents that shows that already marriage was subsisted and they are now drawing some maintenance amounts. Under the circumstances, 2021 and 376 case, they have in charge sheet it was given. 366 was deleted, 376 inserted, and 420. And the matter FIR was that by 420, 120 because by cheating they in the name of marriage they kidnapped. After that charge sheets filed, 366 deleted and 376 introduced. Now my submission is that since marriage is still subsisting and some maintenance was also drawn at this under the faction circumstances, whether 376 charge sheeted is under section 376 maintainable or not. That is why, that is my humble submission at that end. She is still a wife. And this occurrence was in 21/12/2/21. FR in 10/2/21 FR.
By the last order, NBWI was kept in abeyance and you were granted liberty to appear. Whether you appeared or not.
Yes, I think appeared, my lord, but
What think?
yesterday I have made one to contact my lord.
From last 5 years, he's awaiting the trial also. 21.
Anyway, so my lord, then your lordship is one day fix my lord some on in addition to submission documentary evidence. 1 week time maybe I will bring the certified copy to. Otherwise, orally, I think, but I cannot.
May dispose it of lordship. Let him appear before the trial court. It may be disposed of.
But whether 376 under
Unnecessary
a wife.
pending lordship in this honorable court.
It's a maintainability, why this proceeding will continue under section 376, still he is a wife drawing some maintenance. That is the questions. What is this abuse of process or not? Prima facie I say that 370 is not there, my lord. If he is so, if she is wife. My lord, page 41. Charge sheet starts from page 38, page 42. And 41. Instead of 366, now 376 inserted. But when she is a wife, she is still wife last 5 years. In between something happens and domestic violence or like that. Now they want that we should be suffer for this FIR which is filed 21 and charge sheet files in 21.
Lordship, let the victim may pay lordship.
The victim was made party.
Newly made party.
But the notice not issued.
Notice was issued is given.
How was victim made party by filing application?
I was suggested that victim should also make party. They have suggested that is why direction was given. So accordingly, she was made party. Now, if she corroborated that she is wife, then I think this proceeding is the.
Lordship, this is the party notice must go, lordship. The party now in this case, lordship.
Once she says that she was kidnapped, then 376. On another case, she is claiming maintenance as a wife. So this proceeding, my lord.
Who is Hasina Begum?
Yes, Hasina Begum. My lord, there is a, my lord, kindly say Annexure D, Annexure C, my lord. These are this Okalatnama, Kabilnama, marriage. This is admitted facts. My lord, page 26 is the.
We are dictating. Please stop. LPP and so and so appearing for respondent number 2. It appears that by filing amendment application, the victim has been added as respondent number 3 and notice is yet to be issued. Hence issue notice to the respondent number 3. That's within 3 days by speed post with AD. Please again on so and so.
Plus.
Whether you have appeared or not.
My lord, I will substantiate my lord document by documents. They fear that even if the NBWS, he will be put in behind because session tribal case he is not getting.
By last order, we had kept it in abeyance.
Yes, my lord. I took my instruction and my lord documented this.
Correction Korean.
Item 29. Yeah, please, your lordship. Lordship, here an additional affidavit has been filed by us, lordship, that is on record. And they filed a reply, lordship, to that. That is not on record, lordship. On 29/7, I was supplied the copy, lordship. Their affidavit.
My lord, the matter relates to the payment of the maintenance, my lord. Payment of the maintenance. They
You
have
have filed reply.
already we have filed the reply, my lord.
Thereafter,
Already we have
against
filed.
the additional affidavit, they also filed a counter. That is not on record, lordship. Subsequent new
Third learned
developments.
counsel for the
They have
petitioner and
stated.
respondent, it is stated that a reply has been filed on behalf of the respondent. Is not on record. Registry to verify and place the same on record. The matter again on.
Highly obliged, my lord.
Please, your lordship. Lordship, this matter may be ready for hearing, but I have not received the paper book, lordship.
Was there any direction to prepare paper book?
So, my lord, there is a POCSO case, my lord, notice.
PCR itself has not been received, it seems, as per last office note. You say it's ready for hearing.
Also, my lord, regarding the notice part also, my lord. So is the section 4 is there.
So that amicus is already there.
MK Brown, amicus is
Okay,
there.
yes, oh, yes.
And we have served the notice.
But learn it for the petitioner. As per office note dated 30/07/26. Here has not been received. Issue reminder list again on.
Highly obliged, lordship.
Here I have filed a written objection that has not been tagged with the record. Written objection was filed on 24th of July.
On filed on
24th of July.
objection is here. This one. Yes, what is the matter?
May I please, your lordship? Lordship, NBW has been issued against me, your lordship. The victim and my elder brother was in love affair, had some love affairs, your lordship. I have nothing to do with this case, your lordship. Only I'm before your lordship because NBW has been issued, your lordship, and I want to participate in the trial, your lordship. My lord.
Where is the FIR?
My lord. FIR is at page 16, your lordship, relevant. type copy is in page 14, annexure 2, my lord. And my elder brother has been granted bail by this honorable court, your lordship. That order is already in that file, your lordship. Page 14, madam.
What is your name?
Ejazul Haq, my lord.
Number 3.
My lord.
Package number 3.
3, my lord. 1 is my elder brother, 2 is my father, 3 is
Seated.
my lord. My lord, may kindly see page number 27, my lord, annexure 4. My lord, got it. Page number 27, my lord.
Yes.
This is the first time after receiving notice, my lord, on 22/1/2026, your lordship, I have through my engaged counsel, your lordship, I have submitted petition to on this first date, your lordship. I have taken time to appear, your lordship.
You have been granted. You say you have been granted bail.
No, my elder brother, who was in a love affair with the victim, had granted bail by this honorable court, your lordship. That order is there in the file, your lordship. I am the younger brother. I have nothing to do with this case, your lordship. Only because, my lord, in page number 27, my lord, on the very first, this is the very first date after receiving notice, your lordship. On this date, your lordship, through my engaged counsel, your lordship, I have taken time to appear. And the next day, your lordship, due to some miscommunication with my counsel, your lordship, I could not appear, and NVW was issued, your lordship, without issuing bailable warrant, your lordship. So my limited prayer is, your lordship, my lord, may NBW may be kept in abeyance so that I can appear, your lordship. Any condition my lord may impose, I am ready to comply with any condition my lord provide, your lordship. I am a student, your lord, 18 years old, your lordship.
Yes.
But his two brothers, the elder brother committed the rape, and the younger brother took her to their house and they raped, the elder brother raped. Now, I'm reading this vernacular of the FIR, my lord, once again. It will be crystal clear, my lord. Vernacular in Assamese. Page 17 of their.
Yes, read.
Number 1, Habibul Islam, Assami, and 2, Zakir Hussain, and Ijazul Haq, Zakir Hussain, Pita Zakir Hussain. মহোদয় সন্মানপূৰ্বক বিধি নিবেদন এই যে মই চৰকাৰী চাকৰি সূত্ৰে বাহিৰত থাকো। ইংৰাজী 12/7/25 তাৰিখে ৰাতিপুৱা অনুমান 6 মান বজাত মোৰ নাবালিকা ছোৱালী ফাৰাহান পাৰভেজ বয়স 15 বছৰে মোৰ নিজ ঘৰৰ পৰা টিউচন কৰিবলৈ মেৰাধজ জাতীয় বিদ্যালয়লৈ ওলাই যায়। সময়মতে ঘৰলৈ ঘূৰি নহাত আমি বিচাৰ পোচাৰ কৰি থকা অৱস্থাত প্ৰায় ৰাতি 11টা মান বজাত মোৰ ছোৱালীজনী ঘৰত আহি উপস্থিত হয়। পিছত আমি সোধপোছ কৰাত ছোৱালীৰ মুখৰ পৰা জানিব পাৰো যে 1 নম্বৰ আৰু 3 নম্বৰ আসামীয়ে ৰৌমাৰী ৰাস্তাৰ পৰা এখন 4-চকীয়া গাড়ীৰে অপহৰণ কৰি কোনো অজ্ঞাত স্থানত এঘৰত লৈ যায়। তাতে ঘৰৰ এটা কোঠালিত আবদ্ধ কৰি 1 নম্বৰ আসামীয়ে ভয় ভাবুকি দেখুৱাই কাপোৰ কানি খুলি 2 হাত বান্ধি অশ্লীল ফটো উঠায় আৰু ধৰ্ষণ কৰে। সেই সময়ত 3 নম্বৰ আসামী সেই ঠাইৰ পৰা আঁতৰি গৈছিল। পুনৰ ঘূৰাই লৈ আহে আৰু ঘৰৰ ওচৰৰ
PCR
এৰি থৈ যায় কেছ কৰিলে 1 নম্বৰ আসামীৰ মোবাইলত আবদ্ধ কৰা ফটো সামাজিক মাধ্যমত প্ৰচাৰ কৰিব বুলি ভাবুকি দি আছিল আমি মান সন্মানৰ কাৰণে গোচৰ দিয়া নাছিলো বৰ্তমানে অশ্লীল ফটোৰ বিষয়ে গাঁৱৰ বিভিন্ন লোকৰ লগত প্ৰচাৰ কৰি আছে 2 নম্বৰ আসামীয়ে 3 নম্বৰ আসামীয়ে এখন 1 নম্বৰ আসামীক টকা পইচা দি সহায় কৰি আছে This case was registered accordingly. Now, charge sheet was already been filed against these three accused. Now, when this first accused, Habizul Islam, was arrested on 19th of August 2025. Thereafter, he was awaited of arrest, this petitioner. Then all along, he was apprehending from arrest and subsequently, this lordship will find my objection Annexure 3, in my objection, my lord, I have stated in para 4 that the statement made in para 7 a criminal petition misleading the facts for which the deponent denies the same father. It is stated that there was no love affairs with the petitioner's elder brother, nor there had been any settlement as mentioned by the petitioner. Rather, the petitioner and his elder brother forcibly kidnapped the victim, who is as about 15 years old, with criminal conspiracy by tightening her hands and took the nude photos and thereafter committed rape. Lordship will find Annexure 1. This is a criminal force they did it, and afterwards he was committed rape. This is not a case of love affairs. Had there been love affairs, then certainly this injury would not have happened. Then, Lordship, the Annexure 1, page 73, my lord. This clear picture of the girl where they tightened the hands of the girl and forcibly she was taken. My lord, para 5, I have stated, my lord. Para 5, that the statement made so there is a false and misleading of the facts, hence the petitioner and his elder brother jointly kidnapped the minor victim girl and committed rape. There is no question of setting aside the NBWA into granting of bail to the petitioner in such heinous crime offense. Since the petitioner intentionally avoided to appear before the learned trial court, even after receipt of summons dated 11/11/2025, 17/11/25, 1/12/25, 15/12/25, and 23/12/25. Thereafter, my lord, on 23/12/25, 6/1/26, and 21/26, the petitioner filed an application. He appeared on and the advocate on behalf of the petitioner submitted the application on 3 occasions. Then subsequently, that is 23/12, 6/1/26, and 21/26. Thereafter, the accused person was remained absent. Lastly, Lordship, in the para 5, you intentionally did not appear before the court below on several occasions. As such, the petitioner in the present case is not entitled to any relief as for misleading of the facts by taking advantage of non-bailable warrant of arrest issued by the court below, which was rightly passed the order by issuing non-bailable warrant arrest on 3/2/26, 16/2/26, and 27/27/26, page 30 to 32 of the criminal petition. But here, knowing fully, he avoided the honorable court to appear. There was summons, thereafter non-bailable warrant of arrest, and before that, he appeared 3 occasions. His counsel appeared and this petition was submitted, my lord.
No, you see, in any case, petitioner,
My lord.
you are only challenging the NBWA.
My lord.
So, for that, why have you preferred a criminal petition? If the order is illegal, incorrect, you ought to have preferred a revision.
That's true.
And where is the question of bail? For that, you have to apply for anticipatory bail.
My lord, with all due respect, your lordship, what my learned senior is submitting, the photograph, your lordship,
No, you respond to our query.
my lord. My lord, because NBW was already issued, your
Yes,
lordship.
what is the remedy against that?
So, my lord, I am just praying to kept.
Don't take
the
us here and
NBW
there.
abates for-
Answer the question.
My lord.
How is this maintainable? This is for exercise of our inherent jurisdiction. When we already have jurisdiction in revision to interfere with the order, why would we invoke our inherent jurisdiction? You ought to have come by way of a criminal revision petition, not a criminal petition. And as far as bail is concerned, for that you have to file a anticipatory bail application.
Praying for bail, your lordship. I am not now praying for bail, your lordship, because NBW has been issued, your lordship. That is why I could not appear, your lordship. So, my lord, I am before your lordship. Just
You know what will happen if we set aside the NBWA?
I'll appear, my lord.
You will appear, and what will happen then?
Trial will proceed, my lord.
Trial will proceed with you behind the bars.
My lord, I'll appear, and because of the NBW only, my lord, I could not appear, your lordship, your lordship.
Even if you appear, you will still have to be granted bail. Will the court grant you bail?
That, my lord.
So you say you don't want bail. Then go inside. Where is the problem?
My lord, I'm just.
Either by way of NBWA or otherwise, if you want to go inside, why have you come here?
My lord, because I am, if my lord set aside the NBW, I'll appear, your lordship, and trial court will verify, your lordship. With all due respect, your lordship, what my learned senior has.
All right, well then let's dispose of. You will appear before and apply for regular bail. What is the matter? Yes, Mr. Chetri. Let it proceed that way.
My lord, may kindly
He says he will appear.
My lord,
Only the NBWA will go. The trial court has to consider the bail application on its own merits.
My lord, NBW may be set aside, my lord. That much limited prayer I have, my lord.
Not set aside, because in some of the cases I have seen, just for kept in abeyance.
We'll keep it in abeyance for till the appearance.
My lord.
All right, heard learned counsel for the petitioner and learned additional PP. Also heard Mr. Swenso appearing for the respondent number 2. This criminal petition has been preferred challenging and NBWA issued by the learned Special Judge Pokso Nagaon.
Yes.
By order dated 03/02/26, 16/2/26 and 27/2/26, as well as subsequent orders. Full stop. The case has already ended with a charge sheet, and the limited prayer of the petitioner is that he may be allowed an opportunity to appear before the learned trial court, but because of the pending NBWA, the petitioner is apprehensive of so appearing. Full stop. Accordingly, on the prayer of learned counsel for the petitioner, to which learned counsel for the respondent and learned additional PP does not object, this petition is disposed of with the direction that the petitioner shall appear before the learned trial court on the next date fixed in the case, and upon such appearance, the petitioner may file appropriate application which shall be considered as per law. Till the next date fixed in the case, the NBWA is issued against the petitioner shall be kept in abeyance. Full stop. Petition stands disposed of accordingly.
Shall be considered, my lord,
As per law.
on merit, my lord. That may be.
We say considered as per law.
No, my lord, that
Law includes merit and facts, both.
already this honorable court also passed in some other cases.
We're not concerned with other cases. This is my style.
Yes.
Good.
Lawless.
Right, Nicholas. Well, here, my lord, I'm challenging the order taking cognizance for quashing. Earlier, your lordship, on 19/6, my lord, your lordship, the respondent appeared, my lord, and lordship has allowed us to file an exemption petition and for consideration of stay, my lord. Now the respondent took time, my lord, on two occasions to file affidavit objection.
behalf of the respondent number one, Lordship, I'm praying for 2 weeks time to file objection, Lordship.
Now on 2 dates, my lord, they have only taken time, my lord, but your lordship, our stay was there to be considered, my lord. So, my lord, the order taking cognizance, my lord, we are challenging, my lord, that is.
When is the next date fixed?
Next date, my lord, is one date is gone, my lord, 29 September, my lord. And court has also issued again fresh summon, my lord.
So 29 September is still some time away. He wants only 2 weeks. Had learned counsel for the petitioner and Mr. and learned additional PP. You are for respondent one. Huh? We're not a party. Okay, cut that. Also heard Miss KLR Yanten, learned counsel.
My name is D. Chakraborty,
Who was there earlier?
respondent number one.
Earlier somebody else appeared. Okay. Give your name.
D. Chakraborty.
Yes, fine. Respondent number 1 and 6, further 2 weeks time to file objection. Accordingly, it is submitted that the case before the trial court is fixed on 29/09/26. Accordingly, list this matter again on 2 weeks or episode date to deduct immediately after 2 weeks. Is the record
So lordship, the interim, your lordship may indicate on next date, my lord, because.
on next date you make the prayer. Now there is no necessity. Next date is far away.
Your lordship, my senior is on legs, so they allow the method to be passed over for the time being.
25 standing.
My lord, here, my lord. Lordship may fix it tomorrow, my lord, and direct the, my lord, to show the name of the, my lord, standing council, forest or special PP forest.
Please the matter again tomorrow, showing the name of learned special public prosecutor, forest department. In the cause.
Obliged, my lord.
May it please your lordship. Lordship, regular bail application, lordship, though charge sheeted today, lordship, 91 days in jail custody, lordship. FIR, lordship, will find on page 15, lordship. There are two petitioner, lordship, one Jamiruddin, alias Hussain, and another is Raju Hawk, lordship. Their name not mentioned in the FIR, lordship. The FIR on page 15, lordship. The victim, it is the allegation that the victim husband has been abducted by this FIR name accused person, lordship, and then demanded ransom, lordship. The victim husband escaped from that their custody, lordship. He kept killing another person, lordship. Against him now he is in jail, lordship. That is on page 44. While rejecting the bail petition of this petitioner's lordship, it is reflected on annexure 5, page 44, lordship. And moreover, the accused number 1 in the officer Afsar Hussain Borbhuya Lordship, he approached before the court below Lordship for bail Lordship. His bail was considered since Lordship charge sheet has submitted. Investigation is over Lordship. On that ground Lordship. My rejection order that is on page 44 Lordship. Although it is in the month of May and their order is 28/7 Lordship.
Your order of rejection is at page?
Page 44 Lordship. Our rejection order is on the first paragraph, Lordship. It is stated that
Who are the FIR named accused?
No, Lordship. In FIR, my name is not there, Lordship.
Whose name is there?
The person, Lordship, the Ashraf Hussain, it is reflected in the rejection order, Lordship. He has taken that person, Lordship. And he has granted bail by the court, Lordship, court below, Lordship. These two petitioners are arrested, Lordship, on the basis of the statement of a co-accused, Lordship.
Person was killed ultimately.
No, well, he fled.
But
The
is this
person fled.
advocate? So there is a different case. You were detained in jail in connection with a different case. Lahore Ghat PS 31 of 26.
That person is the victim, Lordship, who has escaped from the custody of that FIR named person, Lordship. That is the informant husband. He is the killer of this case, Lordship. Second case, Lahore Ghat case. He has killed that person, Lordship. Why? Inform Gilne this husband of kidnap. Against the case.
Yes, anyway, what is the material against him?
But this case is concerned, my lord, they are involved in, my lord, kidnapping that person, my lord, a victim, my lord. A victim identified the persons who are there. Your lordship may see kindly see that their statements, the co-accused statement, and also his own statement, my lord. That will reveal, my lord, how they take my phone.
Victim name?
No, statement of victim is there.
Yes. Last part.
Victim is Lordship Abdul Mannan Borbhuya. And he is in jail now in connection with Lahore Ghat PS.
Who is Samsuddin?
Samsuddin, FIR name accused number 4, Lordship.
Is 164 is 183 is also taken. Victim or
2-3 persons are there, my lord.
Samsuddin's 164 is also taken. He is what? Confessing or what?
Yes, madam. Samsuddin confessed.
How is it a confession? If he is a victim, They took our mobile phones.
He also escaped from, although he is shown as an
Three
accused.
persons are there, these 3 persons were taken away.
Then they are made accused.
Yes, ma'am. Then they make the accused after that. Afsar, one is Afsar, my lord. His statement also, he was also, my lord, as per the statement, he was also taken away, but kidnapped.
Afsar Usman actually he has been kidnapped. And he has murdered another person. That's why Casey is in jail.
Application.
बेल पाहिजे अफसर हुसेन बेल पाहिजे बेल पैसे ऑर्डर
He has named Shankar alias Sitaram Hussain from Ratrabari. Who is this? Hussain? Only Hussain. Ali Hussain, Sajibur, and Riazul.
Here the petitioner lordship Jamir Uddin, he is Dolgam, village Dolgam, Ratawari, PS. And Raju Hawk, village Karola, PS, Nara Hat.
So forgetting the rest, if we take the Abdul Manan's statement, then there doesn't appear to be specific implication. He names one Hussain of Ratabari.
Yes, ma'am.
Whether that Hussain can be any number of persons.
10, ma'am. Kindly see one Zamiruddin, my lord. His statement also there, madam. This his statement
His
also-
statement we cannot consider.
the story behind, madam. Person to whose house the victims were brought, my lord, there his statement is
He got them.
He found a firearm in the room. He took that firearm and shot the lock and then escaped. Took shelter in a village where they thought he was a thief and beat him up. He again escaped and went to another village. There also they thought he is a thief.
First he fled from the kidnapper, then from the public.
$91 days.
Samsuddin was later on exonerated during the charge sheet. He was made a witness. As per the charge sheet, the analysis of CDR record, they were arrested.
Yes.
There doesn't appear to be any direct implication by the victim himself. Okay, now treating Samsuddin as a witness, we have to see his statement also. He also does not implicate. Samsuddin does not implicate.
Samsudin, no.
Now Samsuddin is a witness.
Samsudin is a witness now.
So his statement has value. If he does not implicate, then this one is also not very clear which Hussein he means. You heard learned counsel for the petitioner.
Raju Hawk name is there, right?
Where? Who's where?
In this.
The second petitioner. Whose name is his name is mentioned by whom?
Samsudin.
10% Samsudin. Accused number 4.
No, he is not an accused now in that after the charge sheet.
Yes.
Now witness.
No, he does not. Does not take Raju Haq's name in his 183 statement. Not
Found somewhere, well,
Hmm?
Raju's name I found somewhere. Other statement.
According to him, even this Afsar is a victim.
Afsar is a victim, brother. Afsar has given the statement.
Hmm?
Afsar got
is
the
a
bail.
victim. Afsar has given the statement.
He got bail as an accused,
Yes.
then became victim.
Yes, even became victim.
But in
But
no,
he-
Afsar Hussain is shown as absconder. He hasn't become victim. So his statement had learned counsel for
He has statement regarding it.
I had learned counsel for the petitioner. It's an LPP. Is an application under so and so. The disorder, no? 28/7/26. Last para, gist of the prosecution case.
Yes. 28/7.
Is submitted by learned counsel for the petitioner that co-accused of this case, Afsar Hussain Barbhuiya, was granted pre-arrest bail by the learned additional session judge FTC Kachar by order dated 28/07/26, copy of which has been placed before the court. submitted that since the investigation is over and the petitioner has spent how many days?
91 days to
91 days in custody, he may be considered released on bail. The TCR, scan copy of TCR is called for has been received. We'll start upon perusal of the statements of the witnesses as well as the charge sheet. It appears that the petitioners were arrested on the basis of all records only, besides statements of co-accused which are not admissible in evidence. Para having regard to the material as well as the period of detention. Further, also considering the fact that another co-accused has been granted pre-arrest bail from the prayer for bail is allowed. Accused so and so shall be released on bail 50,000 to charity like mom. Provided that the petitioner shall cooperate in the trial and shall not try to influence or intimidate any witness.
to the satisfaction of lordship in connection to the satisfaction of the now is the lordship PRC case charge sheet has submitted lordship where case was committed or not, it is not ascertained, but in connection with PRC case number 669/2026
To the satisfaction of the concerned
Uh,
magistrate stroke court. Okay.
Kathar Silchar lordship. Highly obvious.
Very pleased. This is the regular bail application, my lord. Krishna was arrested on 15/11/2025, my lord, under section 64, subsection 2 of BSNS Act. My lord, and I read it section 6 of POSCO Act. And my lord, now my lord, trial is going on, my lord, as many as 2 witnesses has been examined, my lord, victim as well as our murder, my lord. The learned trial court, my lord, both the witnesses are declared hostile, my lord. You'll also kindly see turn page 38, 39, and 40, my lord.
This came up another day, earlier also. Victim is hostile. I think some other accused. I think we have passed order in case of one co-accused. I've forgotten what order is passed because I remember this deposition. We have read this not very long ago. I think last week itself. Co-accused the bill to check করবে পারা যাব. What is your name? Baraik.
Ramjan by Singh.
I think we have passed order in respect of one, I think, maybe this, among. এইকেইটাক চাই ল'ব হা কোনোবাটো এই চাৰিটাৰ ভিতৰত যিকোনো take up after some time. You don't know whether co-accused has been granted bail. What? Yes or no? No idea. Tell me. Maybe your colleagues will also know it. It's last week only. So it came up, I think, last. Yes. Huh?
May I please, Lordship?
Yes.
Regular bail application, my lord. Petitioner behind the bar 2 days, 58 days out of 60 days, my lord.
Charged. What is the case?
I am not the FRNM request, my lord. FR at page number 15, my lord. 9, translated copy, 9. Allegation is that the FRNM accused person has viral some obscene photo of the victim, my lord. And the main accused is already granted bail by the learned court below, my lord. 59 days today. Main accused granted bail, man.
Co-accused granted bail. What to do?
By the main accused, my lord, not by me, my lord. In the, there is a statement of victim, my lord. The victim does not implicated me, my lord.
How will victim know who pasted the photograph? The polls.
Here is the page number 17, the forwarding of main accused, round number 2.
Yes. Informant.
by the main accused, not by me. Say evidence.
They have only implicated Minas,
Lordship.
both the victims. They have not implicated present petitioner. Eh? 183. I don't see here.
In accused already granted bail, my lord, I will cooperate with the trial, my lord.
But even from that, it appears Minas is the main accused. He is the main perpetrator. Hmm? Forwarding report, they say both of them.
Round number 1.
This is forwarding of Sunny Dole. Confessedly. He did the morphing and handed it over to the principal accused. If he handed it over to the principal accused, then it was him who did the circulation. Anyway, there is no option now. The principal accused has been granted. Learned counsel for the petitioner. Additional learned amicus appearing for the respondent number 2. The brief of the case is that page 19. Huh? They submitted that the main accused of the case, Minazuddin, has been granted bail by order dated 08/07/2026 by the learned session judge Bogali, a copy of which has been furnished. Further submitted that the present petitioner, who is the co-accused, the case has already spent about
59 days.
59 days behind bars and accordingly deserves to be released on bail on ground of parity. Para having perused the material on record, appears that the present petitioner stands more or less on the same footing as the main accused. Therefore, he is also entitled to be released on bail. The principle of parity. Furthermore, the investigation of the case is of para. In consideration of the above, the prayer for bail is allowed. 50,000 2 sureties. provided that the petitioner shall regularly participate in the trial if one commences and shall not try to influence or intimidate the witnesses in manner.
Second session Judge Bozali.
Satisfaction of session.
May I please, your lordship? Well, 2 days, 53 days behind the bar, my lord. Allegation is that 1 kg 23 gram, my lord, ganja was recovered from his house, man. 53 days, my lord, he is in jail, my lord. 53 days, my lord, intermediate quantity, my lord, maybe consider length of detention, my lord. The only accused in this case, my lord. 37.
Submitted.
My lord, he is in jail, my lord, he will face the trial, my lord.
Submitted, you apply there.
Then
we'll have to see the TC.
TCR may be called for.
That CS has been submitted by CS number so and so. Call for the scanned copy of the TCR.
For 8 of 2020. 7 2020.
Date may be. Yes.
Yes, 38, Mr. Dotto, I think you were there.
I'm sorry, madam. I had as a 58. It's a regular bail application, my lord. The lordship had earlier rejected the same, my lord. That your lordship will find the rejection order. It starts from page 89, my lord.
Standing counsel. NC.
Then your lordship may fix it day after tomorrow, my lord.
All right, on the prayer of for the petitioner is the matter again on Wednesday.
On 5th, my lord. I am obliged.
I plead your lordship.
Hmm.
Lordship, service is awaited upon respondent number 2. TCR has been received and may be kindly retained till next date.
All right, heard learned counsel for the petitioner. Counsel. So and so enters appearance for respondent number 2 and seeks time to file objection. TCR has already been, scanned copy of TCR has already been received. List the matter again on. So and so in the meantime, objection may be filed by respondent number 2. Yes. So you received notice, isn't it? You serve copy. Otherwise, it will again get adjourned on the next date.
All right, your lordship.
My pleasure, lord. But here, my lord, 2 days, 60 days, my lord. And
What is the allegation?
my lord, 78, 2 and 351 VNS, my lord, those are bailable. 12 POCSO has been added, my lord. For circulating photos, my lord.
Eh? Not completed. 60-day offense.
Lordship, 60 days, sir. Three years conviction.
Third learned counsel for the petitioner and learned additional PP. An application under so and so. The allegation against the petition. The petitioner obtained the photographs of the minor daughter of the informant. Threatened her with dire consequences. The nude photos were made viral on social media. An additional PP submits that the investigation is not yet complete. The petitioner was arrested 05/06/2026 and has spent 60 days in custody. The period of detention in respect of the registered offenses 60 days. Having regard to the above, the prayer for bail is allowed. Shall not try to intimidate.
It shall just POCSO, Shankardev Nagar, Hosai Manor. Obliged.
It's a POCSO case notice has been served on the respondent number 2, Lordship. Actually, TCR may kindly be called for them, Lordship.
All right, heard Mr. Learned counsel for the petitioner and learned additional PP, Mr. So and so enters appearance for respondent number 2. It is an additional PP. That charge sheet has already been submitted via CS number. Hence, call for the scanned copy of the PCR list again on
10th of before 15th August, Lordship, if possible. I am behind the bar for 53 days and FIR is at page 15, nothing material, Lordship.
and fix a date if it comes well and good.
It will come from on online, Lordship, scan copy. Before 15. 10th August. Obliged.
Yeah, with a regular bail application, petitioner was arrested on 22/6/26 along with another accused minor while they're possessing a scooter, and a contraband was offense under NDPS minor section 21B, read with 29 intermediate quantity minor, and around 12.23 grams were recovered from the rider of the scooter minor. Petitioner was a pillion rider minor, and already is 43 days in custody minor. And then his body search was also made from the petition, but there was no opportunity was given to the petitioner for searching in presence of magistrate or a gazetted officer manner. That violation of section 50 is also there, although nothing was recovered from him manner. It was recovery was made from the co-accused man. As per the FIR manner, which is at page 15 man. FIR.
Your name is Moniruddin.
Moniruddin. Yes. Already 43 days man, already custody man.
Yes, PV. No, that we know, but recovery was made from the other accused, it seems. All right. He was present.
But it is there is no material that's
What about 50 notice?
Again, that 50 notice was not, neither he was produced before
No mention of that in the forwarding.
or magistrate or gazette officer. But that is already one for 42 days earlier also. Last date also, my lord.
It is not in the case diary. Where will you find it? Why he keeps certain documents with himself while sending the case diary?
India pilot FIR itself, it is said that the search was made by this.
Let us see the case diary.
That cannot be done even in view of the Honorable Apex Court judgments, my lords. Lordship knows, my lord, anyway. That was done by the. Sir, but not produced and submitted that is not produced. No,
Not produced?
With arrest.
What is not produced? Clear in your submissions at least, so that we can understand what you are trying to say.
Lines of section 50 was not there. It has to be strictly followed, my lord, in view of Honorable Apex Court judgments, my lord, lordship.
A mention of 50 is there in the statements of some of the members of the party. But why is the notice itself not here?
Either produced before magistrate or gazette officer, my lord.
No, they say written consent was obtained from them
that
for search by
presumption-
the undersigned in the presence of witnesses. So where is that written consent?
That presumption is there. On the basis of presumption, they cannot arrest him, my lord.
You specifically say the written consent was there. That is why we want to see where is the written consent. All right, get the written, get
Not even if written of consent is given, that option cannot be given, my lord, because the compliance of section 50 must be followed strictly, my lord.
that is the
That is what the
compliance.
Honorable Appeals Court, my lord, in state of
They
Rajasthan.
have to be informed of their rights.
Yes, my lord.
They were informed, they said, okay, fine, you sir, so we don't
But
want
that
to
is
go to
their
magistrate.
presumption, but option
No,
cannot
no,
be
they
given.
say it's written on.
But this judgment I am also producing, my lord. Kindly produce for a moment, before lordship decides. I don't know this. Para 19, my lord, that is, even they are given the option, but that cannot be, they cannot bypass that compliance of section 50, my lord, by simply giving the option, my lord. And that presumption only raises, my lord. So it was not there. Para 19, my lord, only. Para 19. And also there were also, they also dealt with the pattern regarding this. It's immaterial whether they have.
It is completely different.
It's immaterial that they have whether given him the option, my lord, but that
No, it doesn't say so.
is there, my lord.
It is said giving them a third option is not permissible.
Yes,
In this
that
case,
that
they
is
were
it.
given the option
That
of
is
the
yes,
a third
okay.
option besides gazetted officer and magistrate. They are given the option to be searched before the superintendent,
That third
who was
option
part of the raiding party.
Yeah, also the third option was given, ma'am. That is by the search by the police raiding party, ma'am. That to the raiding party, ma'am. So that option they cannot give, ma'am.
Go on reading. Go on reading. Bottom line.
Yes.
Where
We are not expecting any opinion on the question whether if the respondent had voluntarily expressed they wanted to be searched before PW 5 JS Negi, the search would have been vitiated
or not. So you are saying this is law. And court says we are not expressing any opinion.
But that matter in the preceding paragraphs, in para 17 also it is dealt.
Yes, I think we have heard enough. We'll produce the learned counsel for the petitioner and
his 43 days. That part
counsel
also
for the. We are not releasing even in 100 days.
It's like intermediate quantities, man.
Yes, in case of intermediate quantities, if you go by our previous orders, you are lucky to get a hearing for so long for 43 days, only because of section 50. For the learned additional people, he has been received. Where a contention has been raised that so allegedly recovery was made upon personal search of the accused persons on notice under section 50 of the NDPS Act, which is mandatory, was not complied with. Around perusal of the CD, there is reference to compliance with section 50, but no document in this regard is available. Although it is stated that written consent of the accused persons was also obtained. Learned LPP to produce the documents in support of the contention that section 50 of the NDPS Act was complied with while effecting the recovery. On Thursday, furnish a copy of this order to learned additional PP.
May I please, Lordship? But in this case, my lord, as on today, 22 days behind the bar petitioner, my lord.
offense under section 303, subsection 2, deals with theft. 317 subsection 2, received stolen property. 317 for habitually received stolen property. Read with section 13(1) Cattle Preservation Act and 11(1) ADE Ace of Prevention of Cruelty Act. Prevention of Cruelty Act sections are available. As per our information, search is submitted in this case. And I have the CS also, CS number also. So, considering their length of detention, since the investigation is over and all vehicles are get Jimma also, already given Jimma also. And
who are you? You are the owner
I am
of
the
the
driver, my lord. On a driver, my lord. Not owner the vehicle, not owner the cattle, my lord. And in the FIR, it has been mentioned, my lord, as a, there is two petitioners. We both are driver, my lord. And two vehicles were detained. Kindly consider them, my lord, since investigation is complete and length of detention 22 days. 16 page, my lord, FIR, 11 part.
If charge sheet is not there,
Yeah, is not.
how many days now?
22 days, minute.
Only.
Uh,
All right, stay some more time.
my lord.
Stay some more time. We'll call for the charge sheet.
Kindly
Third
consider,
learn-
my lord, as
Counsel for the petitioner.
the driver only. Our involvement is
Excellent.
very limited, my lord.
PP. Yes, yes, very limited. It is hidden behind everything, puffed rice chips and everything, and you don't know anything.
Actually,
Don't claim innocence. Another addition of PP. As a result of the scanned copy of the TCR, it is found that the charge sheet is not available, which is, however, necessary for considering the instant application. Call for the scanned copy of the charge sheet. Again on.
my lord, 24, my lord, it will so long. Can it be 10th August, my lord? Already 22 days. Next Monday, my lord, it was 10th August.
You can again say then, only 30 days.
10th, my lord. Before 24, it will so long, my lord. 10, so
6,
12,
17.
17, my lord.
I'm deeply obliged, ma'am.
Item number 16, my lord, I may be allowed to true.
The prayer of Mr.
Be good.
Matter is dismissed on withdrawal.
Deeply obliged.
May it please your lordship. Lordship, offense under section 108 of the VNS law. I was granted interim protection on 18 to 2026. Thereafter, I appeared, charge sheet was filed, TCR has been called for, has been received, my lord. Fact of the case is, my lord, marriage in the year 2015. Wife filed a, one girl child was born in the year 2018, my lord. Thereafter, wife filed a case under 498A in the year 2019. 2021, I was granted divorce, my lord. 2025, I was acquitted in the 498A case, my lord. 26, she committed suicide, my lord, in her matrimonial house. In the FIR itself mentioned, my lord, that for 6 years, my lord, we were living separately, my lord. Page 34 is the FIR, my lord. And I've already appeared before the investigating officer. I have cooperated with the investigation, my lord. Page 34, if your lordship sees, my lord. Married. With due respect, I beg to state that 10 years ago, my sister Praveen Yasmin was married to the below mentioned accused person as per Sarayat law. They started life together and through their wedlock, a girl child is born. Her current age is 8 years. After the marriage, in the context of demanding dowry, the accused petitioner used to mentally and physically harass her. On 27/11/2019, the accused person caused grievous hurt to my sister, and in this regard, in Azahar is Lord Gosaigaon PS case number so-and-so under section 498 IPC. And the police rescued my sister from the accused person. The accused person, despite having my sister solemnize another marriage on 12/12/2025 without taking a divorce, my sister, unable to bear the harassment of the accused, has been living with us since last 6 years. And her daughter also lives with her. But only to deny me the custody of my daughter, my lord, this FIR has been filed. 6 years living separately. How come 108 can be attracted in the matter, my lord? Page 30 is the divorce that was granted to us, my lord, in the matter.
Yes. See, they have appeared. They appeared.
Legal bill was partial to the application number of certificate of the state record.
Saying have you gone through? What is there? So out of sorrow, he committed suicide. Sorrow. Feeling sad. Huh? No, any proximate act, any prompting? It had learned counsel for the petitioner and learned an additional PP. An application under so and so. As per the FIR, the deceased victim was married to the petitioner for more than how many years? 10?
2015 marriage, my lord.
More than 10 years, out of which she was living separately.
From 2019 onwards.
For the last 6 years. Full stop, it is, and the girl was born out of their wedlock. So it is the further allegation that the accused person had demanded dowry and subjected the deceased to physical and mental cruelty. During the period of separation, the petitioner also contracted a second marriage which caused mental distress to the deceased. and according to the informant, it is suspected that the deceased committed suicide due to the alleged physical and mental cruelty, the alleged second marriage of the accused. Para counsel for the petitioner submits that the deceased has been living separately from the petitioner for the last 6 years. Therefore, there cannot be any scope for abatement of suicide. And the present affair has been lodged only to deny custody of the child to the petitioner after the death of the mother. An additional PP submits that the deceased has left behind a suicide note which is available in the PCR. Perusal of the TCR, including the alleged suicide note. There does not appear to be any proximate act on the part of the petitioner. Any material indicating proximate act or part of the petitioner instigating the deceased to commit suicide. Full stop. Pursuant to interim protection granted, the petitioner has also appeared before the IO and statement has been recorded and the investigation of the case is also completed and charge sheet has been submitted. Having regard to the above, the custodial interrogation of the petitioner no longer necessary. Accordingly, the prayer for pre-arrest bail is allowed. The order of interim pre-arrest bail dated
18 to 20 days. Lots of
hereby made absolute the same terms as may be applicable as of date. Full stop. It is further to be noted that the observations made in the present order is only for the purpose of adjudication of the instant bail application and shall have no bearing during the trial. Why should we mention here? What is the point of mentioning this in this order? Will appear, what is there? If it doesn't appear, consequences will follow.
I'm obliged, no, sir.
Oh. 9.
55.
That item 35. Notice to complete assignment নাই ইয়ার পড়ছে নাকি কোনবা Very nice. Yes, that is what we the last in that case also we have we appointed one amicus. Since the petitioner is in custody for 8 months. Okay, we'll pass the same order. Appoint one amicus and fix again on 13(8). It order pass kori dibo. Item number 35. From Mr. Nawaz, please.
For 47.
I'm praying for a short accommodation, Lordship.
Yes. When? Huh?
Need it, Lordship.
All right, next week keep a date. Any interim?
Yes, Lordship. Interim maybe continue.
Interim order passed earlier to continue till. Yes.
My pleasure, Lordship. Earlier, CD was called for use. Delegation to theft up to cattle, Your Lordship. FIR is page number 8, Your Lordship.
All right, when?
Appear for some protection, Your Lordship. Earlier 2 dates.
You did not even appear on the last date. You did not receive.
Technically given us.
Learned counsel for the petitioner. CD is not received list again on. Yes. 12. All right.
Obligers.
All right. CD not received. Interim passed earlier to continue till the next date of listing list again on. Yes, next.
Right, clear, Lord. My lord, in this case, my lord, delegation lordship is, my lord, some irregularities in, my lord, sanctioning loans to the consumers in the bank, lordship. Now, all the staff, my lord, entire staffs have been, my lord, implicated in this case in the FIR, lordship. Now, can you see the FIR is at page 22, lordship? The accused number 2, 1 is the, my lord, the regional manager, lordship. I am the assistant manager, lordship. My duty is to, my lord, distribute the, my lord, management of the, my lord, bank, lordship.
Received.
Now,
take it up to two.
Now the accused number 1, who is the sanctioning authority,
We'll
lordship?
take up at 2.
My lord, I beg to mention, my lord, item 44 already order passed fixed on 17 August. My lord, subject to permission, I am to withdraw this case, my lord. Withdraw, my lord.
Item?
44, my lord.
Item 44. The prayer of Mr.
A.K. Azam.
Azad. Matter is dismissed on withdrawal. Yes.
I'm deep love.
My lord, irregularities as regards, my lord, sanctioning loans, lordship. My lord, the bank lost FIR, lordship, against entire staff, lordship. The petition number, accused number 1 is the, my lord, regional manager, my lord. The petitioner is, my lord, assistant manager of the bank, Axis Bank, lordship. His duty is to, my lord, distribute the, my lord, management, my lord, whole to duty in the staff, lordship. Now, sanctioning authority is the manager, lordship. He accused number. Kindly see the FIR at page 22, lordship. 22, lordship. I am accused number 2, lordship. Mridu Gogoi, lordship. Accused number 1, Gopinath Sonwal, he is the manager, lordship. He is the sanctioning officer, authority, lordship. And my lord, loan is, my lord, sanctioned, my lord, after, my lord, various levels of, my lord, investigation, my lord. Thereafter, it was sanctioned by the, my lord, the manager lordship, who has been granted bail by this honorable court lordship. The can you see one order of this honorable court? My lord, the affair is very long, lordship. My lord, the gist of the affair, my lord, the allegation is, my lord, recorded in the order passed by this honorable court while granting bail to the accused number 1, lordship. May I draw your lordship's attention to that order, lordship? That is at page 37, lordship. Page 37, lordship. My lord, paragraph 3 onwards, lordship, your lordship kindly see, lordship, at page 38, lordship.
Who are you?
I am the assistant manager, lordship, accused number 2, lordship. My lord, this bail application was granted to the accused number 1. He is the sanctioning authority, lordship, manager, lordship, regional manager. My lord, he has been granted, my lord, on considering the, my lord, fact that they already my lord, for long time now, he has not been arrested and status of investigation, lordship, he has been granted pre-arrest bail, lordship. Now, incident was before, my lord, prior to 2 years, lordship. But in the meantime, lordship, I have been suspended. Entire staff has been suspended, lordship. My lord, the show cause notice was issued. I am under, my lord, disciplinary proceeding, lordship. My lord, case is entirely based on, my lord, documentary evidence, lordship. As my suspension is there, lordship, I have stated in paragraph 5, lordship. So, my lord, in such a case, lordship, as already has been granted bail to the main accused who is sanctioning authority, lordship. So, my custodial interrogation may not be necessary in this case, lordship. My lord, already FIR was my lord dated 3/2/2024, lordship. Now more than it is, my lord, 2.5 years, lordship. And considering that aspect, my lord, the accused number 1 has been granted bail, lordship. My bail petition may be considered. I will cooperate with the IU, lordship. My rule is not there, lordship, because I am only authority to distribute the, my lord, work to the, my lord, management, lordship.
Yes, people.
Is also there. And submitting, if my lord, Gopinath Sonwal is involved, he has been granted bail, lordship. My lord, obviously, my lord, parity is not applicable in the, my lord, bail application, lordship. Now, in the present case, lordship, if he is involved, lordship, he is the, my lord, sanctioning authority, lordship. He has been granted bail, lordship.
I may be considered lordship, my application may also be considered in positive way lordship. Well, I will cooperate with the your lordship. In the meantime, 2 years lordship, my lord.
So if you say parity is not applicable in bail application, what is your case?
My lord, ground of allowing the bail lordship, that may be considered lordship. That is applicable lordship. On what ground it is, my lord, allowed lordship? Well, the same ground is also applicable with me lordship. I am in the not in the office lordship. I cannot accede with the documents of the office lordship.
Babul Gogoi is different.
I am Midhu Gogoi alias Midhu Pawan Gogoi.
I think fellow hasn't done anything directly, maybe in conspiracy, but from this your note, his photograph is there. But against the other loan applications, everything, nothing was handled by him. Those are handled by others. So what to do? Branch manager is given then. He appears to have I think, lesser involvement than the branch manager, because directly, other than appearance in of his picture in the photographs, so he can
That is charged lordship. Under that charge proceeding is going on lordship. I am passing the proceeding lordship. The staff is under was under suspension lordship. I'll cooperate, my lord. Investigation will be progress for last 2.5 years lordship.
Your man is quite clever than the others. He was pulling the string from. He's pulling the strings from behind.
I don't know, but his duty is, my lord, to distribute the, my lord, work to the, my lord, staff loss. In presence of the branch manager, my lord, my duty is, my lord, limited loss.
Third learned counsel for the petitioner. Order dated 25/6/26. Okay. Third and fourth paras. Fifth para also. The CD as called for has been received. Perusal of the same, it appears that the petitioner involvement arises from the fact that he was seen in the photographs along with the other co-accused respect of the sites which were visited in course of the exercise pertaining to grant of loans in a fraudulent manner. It further appears that the case is mostly based on documents. The main accused of the case, who is the branch manager, had already appeared before the IO. The petitioner, along with other branch staff, remain under suspension, and departmental proceedings are also continuing against the petitioner. Having regard to the aforesaid facts, particularly the fact that the principal accused has already been granted the privilege of pre-arrest bail. Prayer of the petitioner is also directed that case 39, para 13. Fourteen, 15 together. Relationship manager. think somebody said branch somewhere. Instead of branch manager, you write relationship manager.
I'm sorry, Lordship, relationships. One is.
What? Relationship.
My lord, relationship was. My lord, accused number 1.
Two accused that there.
Accused number 1 is relationship manager. I am manager, assistant manager. Lordship is.
No, case is only for one person.
Yes, Lord.
You are relationship manager.
No, Lordship.
What?
Branch manager. Sorry, assistant manager, Lord.
You are assistant manager.
Yes.
And that was relationship
Yes,
manager.
Yes.
Petitioner is assistant manager, okay? And the other person who has been granted bail, he is relationship manager. Yes.
Of like that.
Lordship, today is fixed for CD.
This is branch manager. Bank cases are coming. What do you want to do? Charge sheet has been submitted.
See, call for the CD once again.
All right. It is
Short date may be given here.
submitted that CS has already been submitted by case number 166 dated 28/6/2026. Wait for call for the scanned copy of the TCR. Matter again on. Thousand days. What is this? What is this challenge about?
The main copy is, it is okay, Lordship. Yes. May not be a great matter, Lordship.
You are challenging an order 10 years ago.
Yes, Lordship. There is only two ground, Lordship, I have. Execution which one? That was execution date. Lordship, this case is very urgent because I have been paying the order money, Lordship, and there is no proof of proof that she is my wife, Lordship. It is already proved by the CGM court, Lordship, that you are not the wife of this petitioner.
Where is the order?
Order, Lordship, it is annexed. Annexer 2, Lordship, page number 1219.
IA.
Aye, Lordship. Lordship, kindly see the order. Actually, fact is that this lady was married
Page,
23
page.
12, Lordship, 12 to 19. This Mary was married to one another Jiten Busmutari, Lordship, 23 years ago, Lordship. And thing is that the principal judge, family court judgment was expurtive order, Lordship, and the order was not awarded to me. And after many years, Lordship, 2024, I was arrested, Lordship, due to the non-payment of the execution money. And then I have, it was informed to me, Lordship, that an order has been passed by this principal justice. This is the two grounds, Lordship. And the CGM court judgment was passed in 2023, Lordship, 22, Lordship. Lordship, it is clearly mentioned in page number 18. Kindly see page number 18.
So, what we, anyway, there was, it is, CSM did not say married or not married, he said not guilty. That is all.
Not married, Lordship. My Lordship, Lordship,
Where is the impugn order?
Lordship,
Impugn order is where? Where is the order? Impugn order.
the, yes, Lordship. Yes, Lordship. Lordship, I have written in my petition in paragraph number 3, Lordship. I have received one notice, Lordship, in 2014, Lordship. And he has filed a case in 2014. And on that day, I appeared before the court, Lordship, before the family court without my engaged counsel, Lordship. Because family court engaged counsel is not mandatory, Lordship. That's why myself appeared before the family court, and I am a government employee, Lordship. And I am sure that she is not my wife, and I can prove the matter, Lordship. And I was waiting in the waiting room, Lordship, and I do not know the procedure. I have to submit the Hazira, Lordship. And nobody called me, Lordship. That's why on that day, nobody called me. At the evening time, I thought that my case has not raised today. And I came back that day and thought that next time I will get any receipt, Lordship, to appear before this court. And next time I have not received any notice from the court. That's why the Honorable Court passed the expertise order and proceeding expertise. And on the basis of the only PW affidavit, Lordship. The Honorable Court has passed this order to give a maintenance of rupees 2000, Lordship, and the evidence, Lordship, they are relative only, mother and one another's sister, I think, Lordship. This is the
fact, Lordship, and the judgment was not awarded to me up to 2024, Lordship, when I was arrested by the police, Lordship. Then only it was informed me that for this reason you have been arrested. That's why it is delayed, Lordship. And
in the month of November,
Yes.
it is directly to appear before before.
Yes.
Accordingly, he appeared. Honorable Court on
Yes.
respondent. Otherwise, nobody will.
Actually, Lordship.
Now
Yeah.
Execution cases.
Execution, yes, so the execution case is going on, it was not awarded to me.
To suppress by him.
Yes, fact is, it is mentioned here in paragraph number 4. Suddenly in 2000.
Paragraph number 4. Before. From exhibit. In handwriting written. Yes, yes.
Which paragraph?
No, nowhere in fact. I have seen from the.
Lordship, actually, may I explain the basic fact, Lordship? Only 2 minutes, Lordship. Kindly this could just give.
You say you received a notice, you went to the court, you sat there and you came back.
Lordship,
And after that, you waited for 10 years.
Lordship, actually, I thought that another notice will come to me, Lordship, because I am a general person, Lordship. Lordship, I have given to judgment. Actually, Lordship, basic fact, Lordship, may I explain only 2 minutes, Lordship? Actually, about 23 years ago, this lady married to another.
Yes, we have seen that.
Yes, Lord.
Some Bosumotari man, they have a daughter or
Yes,
son
Lordship.
or whatever.
After 23 years, Lordship, he came to his mother home, and there is a quarrel between their mother and brother sister, and he approached to me to let out a room, Lordship, in my home, Lordship. And on sympathy, I have given a room, but he was very irregular in his rent, and finally he dissatisfied. That means there is a quarrel, Lordship, in the 2014, Lordship, and as such he left the room, Lordship. And after leaving the room, he filed 2 cases, Lordship, not only one. This one only one case, and another case that is 498 case, Lordship. I was informed, I have received notice, and regularly I appeared in the CGM court, Lordship. And
judgment, lordship judgment passed in favor of me, lordship, in this case, lordship. Actually, there is no intention, lordship. Intentionally, if it is intentionally, I could not appear in the CGM court, lordship, in the 498 case, lordship.
Right. About the incident. Both of them.
A relationship does not mean that it is.
Relationship means landlord tenant is also a relationship.
Yes.
There.
Relationship does not mean.
Maybe something, we don't know. That is, in fact, not for us to decide at this forum. But we are at this stage, we are only concerned as to how acceptable is his explanation. So we'll see.
And lordship, I have received the WS lordship given by my colleague lordship. And in the WS, nothing is written. Only one sentence I have got again and again. Explain the complainant has not explained delay of each day, day to day, lordship. Day to day, I have not explained. This is only written many times, lordship.
In the delay.
I have not explained day to day lordship. This is the only, but I have only two ground lordship. One is that it was ex parte order and order was not aware to me and it was informed to me when I have been arrested in the year 2024 lordship. And second thing, I was waiting for that.
You were arrested in pursuant to a distress warrant.
Yes, lordship, by the police lordship for warrant, not executing the that is execution please. This is the main fact, lordship, and I was waiting for that CGM judgment, and CGM judgment it was acquittal, lordship, that it is written that there is no any proof. He is failed to prove that this petitioner is the husband of this complainant, lordship. That's why I thought that, lordship, another case I have no any another case. This is the thing, lordship.
All right, we'll see.
Lordship. Obliged.
May I please, Lordship? Lordship, there is some mistake, my lord, from our part, my lord, in drafting the petition, my lord. My lord, we wrongly named the petitioner name as Aminul Haq, my lord, instead of Aminul Islam, my lord. And my lord, his father name also been wrongly, my lord, written, my lord. But my lord, if the lordship may peruse the law order, my lord, where my lord bill petition was allowed, my lord, it is not based upon the personal involvement, my lord. It is based upon the my lord, medical report, my lord. That correction may be made, my lord. This is my humble prayer, my lord. We admit, my lord, there is some mistake from our part, my lord.
What did you submit? I cannot follow. What personal?
It's my lord. Pardon me.
Just now you submitted something other than the name.
Yes, my lord, not personal involvement, not considered, my lord. Based upon the medical report, my lord, bail petition has been allowed, my lord. Due to my page 9, my lord. Injury report, based upon the injury report, my lord. Para 4, 5, 6, my lord.
Yes, what is wrong with it? Injury report was perused.
Yes, my lord. No, my lord. My name been wrongly mentioned in order, my lord. As my lord, I wrongly drafted my name, my lord. Petitioner numbers 1's name, my lord, wrongly written, my
So your name is required to be corrected.
Yes, my lord.
What else is required to be corrected?
Father's name also, my lord.
So why are you referring to para 4, 5, 6 injury report and all that?
No, my lord. I am.
Not by other statement and all this.
Meeting,
So in the injury report, what is the name?
no, my lord, I am not submitting that, my lord. I pardon me, my lord. Lord, my only submission is that, my lord, there is, while lordship was allowing the petitioners on bail, my lord, personal involvement not been, my lord, not been taken into account, my lord. It is all based upon the report. So, my lord, my name may be corrected, my lord.
What has got to do with correction of a name?
No, my lord, I
The
admit, my
reason
lord, there
for
is some
granting
mistake
bail,
from our
huh?
part, my lord, while drafting my petition, my lord.
So confine your statement to that. Why are you
My lord,
unnecessarily
my-
confusing us?
My lord.
But referring to all in third Learned Council. IA has been preferred seeking correction of the name of the petitioner as well as that of his father, which were wrongly drafted in the bail application itself. Stated that the name of the petitioner is Aminul Islam.
Yes, my lord.
And not Aminul Haq. That of his father is Halimuddin.
Yes, my lord.
Not Shahjahan Ali. There is the
Bail petition number, my lord, 1523, my lord.
it appears that in the concerned bail application that is AB 1523 of 2026, the petitioner was shown as Aminul Haq. That of his father, that is the petitioner number 2, as Abdul Halim alias Halimuddin. No, not petitioner number 2, and the name of his father as Shahjahan Ali. The present IA, it has been stated on affidavit. The actual name of the petitioner is Islam, and that of his father is Abdul Halim.
Halimuddin.
Halimuddin.
Yes, my lord.
Only Halimuddin.
Yes, my lord. Halimuddin and Abdul Halim, both of same, my lord.
Abdul Halim alias Halimuddin. No, just keep Halimuddin. He's stated Halimuddin only. HALIM gap UDDIN. So accordingly, the name Aminul Haq shall be read as Aminul Islam. The name Shahjahan Ali shall be read as Halimuddin wherever they appear in the order dated 30/07/2026, passed in AB 1523. This order shall form a part of the ordered aforesaid order. I stands disposed of accordingly.
Highly obliged, my lord.
Wait, please, my lordship. My lordship, this is the revisions against the concurrent finding of the trial court. Trial court and trial court. But, my humble submission is matter. There may be chance to settle the matter, Your Honor. Send this matter to the mediation to give one hope to the petitioner.
Why will they list? You got to list. What amount?
8 lakh.
They can pay 8 lakh to the registry. What is the point of this division? No, it is up to you. If you want to send it for mediation, then we can send it. Otherwise, we'll have to hear on merits. Instead of sending to mediation, why don't you deposit something as a gesture of your good intentions to settle the matter? Settlement means what? Instead of the awarded amount, some compromise amount is to be paid. So what are you willing to pay? You say, okay, by 1 month we'll deposit 25% at least. Then we may not even need to send it to mediation. We can settle it here itself. So get your instruction. How much you can pay within 1 month.
Let me be fixed in.
Yes. What do you do? What is your profession?
I will take instruction from my client, whether he
So
will
no-
pay 25% or not.
Huh?
I will take instruction.
What does he do? Is this a business or service?
No, he is the daily labor.
Daily labor, 8 lakhs.
Sake amount was 4,70,000,
Hmm.
and in the trial court it was fine was imposed.
All right, learned. Counsel for the petitioner submits that there are chances of a settlement. Is further submitted that the petitioner may be willing to deposit part of the compensation awarded. Accordingly seeks time to obtain instructions. So accordingly is the matter again on. After 2 weeks, give a date after 2 weeks. Okay. For instructions.
Pass.
My lord, the petitioner is making regular payment laws. We are under settlement laws. Out of 13 lakhs 20,000, we have already only 2,75,000 is due to pay laws. Yesterday, he made a payment
Counsel
of
for the
40,000.
petitioner submits that the respondent has been making payments and of the total amount.
Petitioner is making payments.
Huh?
Petitioner is making payments to the respondent.
Petitioner, okay. The total awarded amount only an amount of 2 lakh.
2,75,000.
75,000 remains to be paid.
Out of 13 lakhs 20,000.
So with total amount of 13 lakhs 20,000. Next is due when?
After 4 weeks, at fixed date.
Is the matter again on given date after 4 weeks.
Hard
learned counsel for respondent.
Please, your Lordship. Lordship, can it be taken any other day, Lordship? My senior lacks in another court.
He may have already been submitted because further proceeding in the case was stayed. Further proceedings in CR case means what? That means. Huh? After GR, it is now CR. What does that mean? That is after submission, I think. No, it is a final report. Final report was submitted. Then police Naraji was submitted. Then order dated this 21/8/24. So this Naraji must have been registered as a complaint case. So what will you call? What are we supposed to call for now? Finish record. All right. On the prayer of learned counsel for the petitioner, is the matter again on
Thursday, Lordship, next week. Interim maybe.
interim order passed earlier to continue till the next date. Yes.
Obliged, Lordship.
My pleasure, Lordship. FIR is on page 11, my lord. FIR is on page 11. I beg to state that on so and so at about 11 p.m., my 16 years minor daughter, namely Jasmina Khatun, went out for toilet. The accused number 1, along with other co-accused, in a pre-planned manner, dragged my daughter and forcefully kidnapped her to an unknown place, and the accused number 1 committed rape upon her for 2 days. We started to search for my daughter, and on 29/5/26, we recovered the victim from the resident of the accused. Due to ailment of the girl, there was delay in lodging of the FIR. But the original fact is that, my lord, accused number 3 and the alleged victim developed relation through social media.
It is not available. Oh, this is motion item.
At least, my lord, accused number 1 and 2 maybe.
What is accused number 1 and 2?
They are just brother-in-law of the accused number 3, my lord. They informed the matter to the police station, and the police came and took the girl, victim girl, alleged victim girl, to their parent house. As being relative of the accused number 3, my lord. Maybe.
All of you were named. All of you were named in the FIR, and it is a case of abduction first. We could not have carried it out alone without your help, if true. CD, notice to respondent number 1. 2.
Bless me.